the President of the New York State Bar Association, David Shraver, the New York State Council of Governor and Executive Deputy Attorney General for Social Justice, Mylan Dennerstein, Honorable Jenny Rivera, Associate Judge of the Court of Appeals, Chief Administrative Judge, Gail Perdeni, Deputy Chief Administrative Judge, Lawrence Marks, and the Chief Judge of the State of New York, Jonathan Whitman. The Law Day ceremony will now begin.
Welcome, State. We're going to do the Pledge of Allegiance. Okay. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Now you can sit. What a great crowd. Great to see you all. Welcome to Court of Appeals Hall and to Law Day 2014. It is a delight and a privilege for me to preside once again over this wonderful tradition, joined by my 6 colleagues on the Court of Appeals, Victoria A. Graffio, they're sitting in order, the way they should be, Susan Phillips Reed, Robert S. Smith, Eugene F. Piggott, Jr., Jenny Rivera over here, she's not sitting in order, and Sheila Abdul Salam. Eric Schneiderman, our terrific Attorney General and co-host of today's event, is unable to be with us today. He asked me to send you his warmest greetings and to assure all of you of his unwavering commitment to the rule of law that we honor today. We are honored to have with us today New York State Bar President David M. Shraver and Counsel to the Governor Mylan Dennerstein, who both will be speaking to you shortly, and so many other leaders of New York State government, the judiciary, and the great legal community in our state. In addition to those of you see up here sitting at the front, we have 2 of our presiding justices, Karen Peters, the presiding justice of the 3rd Judicial Department, and Randall Lang, the presiding justice of the 2nd Judicial Department. And we're so delighted that they're here. We have a former Court of Appeals judge, always a member of our court family here, Howard Levine. Delighted to see him here. We have the Solicitor General, Barbara Underwood, seated right in the front. We have the Mayor of the City of Albany, continuing a tradition of all the mayors of the City of Albany never miss an event at the Court of Appeals, Kathy Sheehan. So delighted to have you. You got to keep that tradition, Kathy. You know, you can never miss a Court of Appeals event. But don't feel any pressure. Sitting next to Barbara Underwood is the chairperson of the Assembly Judiciary Committee and a great supporter of the judiciary, Helene Weinstein. And the dean of our hometown law school, sitting 1 seat apart from Assemblywoman Weinstein, is Penny Andrews, and we're so delighted. I'd also note that the president-elect of the State Bar, Glenn Lau Key, is here. Glenn? Okay, who did I miss? Now, I know everybody here. Jim Yates is here, the counsel to the Speaker, isn't he? I thought he was here somewhere. Well, he's about to be about. You know what? I have Jim McGuire here as a former counsel to the Governor. So. I won't say those counsel, they're all the same, right, Marla? We don't want to say that. But it's good to see Jim here, and good to see all of you. And I'm sure I've forgotten 9 million people who I should acknowledged. Do I see the president of the state trial lawyers here? Well, like Mike Como, the Deputy Chief Administrative Judge. Ron Youngkins, Barry Kamens, but I'm going to stop. And all of our wonderful judges, etc. Okay, and all of the wonderful students in the audience, but they're going to be acknowledged shortly. Okay, we come today to celebrate Law Day, a day of great meaning to the judiciary and the legal profession. Law Day was created in 1958 to celebrate our democratic values, our commitment to individual freedoms, and our dedication to the rule of law. Each year, the American Bar Association selects a theme for Law Day events across the country that often looks back to our history but is always relevant to our times. This year's theme is American Democracy and the Rule of Law, why every vote matters. I will speak about this critically important theme before I present my own Law Day remarks and then introduce Counsel Dennerstein and President Shraver to make their remarks on topics that we each choose to highlight today. Then we will continue some very special Court of Appeals Law Day traditions, the presentation of Merit Performance Awards to recognize outstanding performance by members of our non-judicial ranks, the Judicial Excellence Awards, which we inaugurated last year, and the Garfinkel Essay Contest prizes. But first, let us reflect on the importance of a citizen's right to vote, and remember that we still face challenges today in ensuring that all Americans have the opportunity to participate in our democracy. Looking back to 1965, Black Americans had held the right to vote for nearly 100 years, but that right was largely theoretical in many parts of this country. Beyond the misuse of the law, criminal acts of violence during the Civil Rights era suppressed voter registration through terror. Citizens who should have had access to the ballot did not. One of the most dramatic moments of the Civil Rights Movement, a movement that was filled with dramatic moments, arrived on March 7, 1965 in Alabama. A group of about 600 men, women, and children began marching from Selma to Montgomery. They marched in response to the death of a voting rights protester at the hands of an Alabama state trooper, and they sought protection for blacks registered to vote. They were ordered to disperse and then attacked with tear gas, clubs, and whips. The horrific events of what came to be known as Bloody Sunday, captured in photos and newsreels, galvanized our nation. That day led directly to the passage of the Voting Rights Act, signed into law by President Lyndon Johnson on August 6, 1965. The Voting Rights Act reaffirmed our democracy and helped to ensure that Americans had the right to participate fully, regardless of race or income level. It continues to be of paramount importance today, nearly 50 years later. I would caution that we cannot call ourselves a true democracy if our citizens are unfairly prevented or discouraged from voting. As we look back a half a century to the birth of the Voting Rights Act, we in New York and around the country must remain vigilant in ensuring that every vote and every voter truly matters. The very legitimacy of our democracy depends on that, and we thank the ABA for highlighting this issue as the theme for Law Day 2014. So I think it really is a very important subject, and all around the country this theme is being discussed and talked about today. Before we begin our formal program, I would like to ask Michelle Perry-Belches to come up to sing the Star Spangled Banner. Michelle?
can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rockets' red cloud bombs bursting in air gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave for the land of the free in the home of the brave.
Just as our democratic system of government is built on the premise that every vote matters, the legitimacy of our justice system rests on the principle that every person has a meaningful right to be heard in court before a judgment may be entered against them. Our commitment to this principle has led to far-reaching reforms in New York over the last years in foreclosure cases, where we now require mandated settlement conferences and appropriate supporting documents and protocols that, along with increased legal representation for homeowners, ensure the integrity of the court's foreclosure process. No one should be deprived of the roof over their head without these kinds of basic due process protections. On this law day, in the wake of the foreclosure crisis, there is another issue of great importance to the lives of New Yorkers that must be addressed by the justice system. That is the adjudication of well over 100,000 consumer credit lawsuits filed in our state courts every year, totaling hundreds of millions of dollars. Most of these actions are brought by third-party debt buyers who routinely purchase large portfolios of delinquent credit card debt, often for pennies on the dollar, and then commence lawsuits against individual debtors based on little more than boilerplate language and a few fields of data from a spreadsheet. All too often, these credit card debts are several years old, have been resold multiple times, and critical documents like the original credit agreement and account statements are missing. By the time these so-called zombie debts show up in court, it is extremely difficult for debtors, 98% of whom are unrepresented, to assess the validity of the claims against them, whether they actually owe the debt at issue, whether the amount due is correct, and whether the plaintiff is the actual owner of the debt. As a result, many debtors who received court papers failed to appear in court. Compounding these deficiencies is the nefarious practice of sewer service, a well-documented problem in consumer credit litigation in which court papers never get served on debtors. In fact, many debtors first realize they've been sued when they find their bank accounts frozen or their wages garnished. It is hardly surprising, then, that significantly more than half of consumer credit cases filed in New York courts result in default judgments. In other words, a judgment is entered in favor of the creditor because the debtor fails to answer or appear in court to contest the allegations. The law requires that a creditor seeking a default judgment must submit an affidavit of merit containing some first-hand confirmation of the key facts in the case, including that the debtor entered into a credit agreement and defaulted in making payments, the amount due at the time of default, and the creditor's legal ownership of the debt at issue. In practice, however, default judgments are routinely obtained on the basis of robo-signed affidavits containing hearsay allegations and few, if any, facts related to the history of the debt at issue. Creditors frequently secure default judgments for the wrong amount of money, for debt that has already been paid or discharged in court, and for debt on which the statute of limitations has already expired. Default judgments have even been obtained against the wrong person. While the vast majority of consumer credit cases filed in the New York City Civil Court, the city courts outside New York City, and the district courts on Long Island involve a few $1,000s, interest and penalties can build up until the final debt far exceeds, to the final judgment far exceeds the original debt. And the consequences of an unwarranted default judgment can be devastating for the typical debtor. Ordinary consumers, a lower income or working person who is almost always unrepresented. Such people can ill afford to have their bank accounts seized, their wages garnished, their credit ruined, not when they're trying to support a family, find a job, and keep a roof over their heads. The problems I have described have not gone unanswered. Attorney General Schneiderman's Bureau of Consumer Frauds and Protection has in fact been highly proactive in investigating and combating deceptive debt collection practices as he has been in so many areas involving consumer rights. Likewise, Superintendent Benjamin Lawsky of the State Department of Financial Services is in the process of adopting rigorous regulations to protect consumers from debt collection abuses at the pre-litigation stage. And Assembly Chair Helene Weinstein continues to be a leader in this area, sponsoring important changes in law to protect consumer debtors as far back as 2008, and now sponsoring the Consumer Credit Fairness Act, a comprehensive legislative reform package that we strongly support and endorse. All of these efforts have helped to inspire the reforms that the court system announces today. We have already done much. Under the leadership of Deputy Chief Administrative Judge Fern Fisher, the New York City Civil Court has created special court parts that focus solely on consumer credit cases with dedicated judges and clerks. Special court forms, including user-friendly form answers and mandatory discovery orders, have been developed to help unrepresented debtors understand and safeguard their rights in court. Rules and policies have also been adopted to address the high default judgment rate and prevent time-barred lawsuits. Nonetheless, a continuing stream of complaints from consumers, bar associations, and advocacy groups, such as the New Economy Project and many others, has made it clear that a more comprehensive and rigorous approach is needed on a statewide basis. No one disputes that consumers should pay their debts or that businesses have every right to resort to the courts to collect what is legally owed to them. But at the same time, the judiciary has an obligation to address inequitable debt collection practices in the courts, prevent unwarranted default judgments, and ensure a fair legal process for all litigants. Therefore, I am announcing a package of reforms which in their totality represent the most comprehensive effort by a court system nationally to reform debt collection litigation practices. These reforms are being issued today for a 30-day public comment period, expiring on May 30th, with implementation by June 15th. They are available on the court system's website, www.newyorkcourts.gov. The first prong of our reform efforts focuses on requiring creditors to submit stronger affidavits containing detailed proof in support of default judgment applications. Every affidavit submitted in support of a default judgment must be made by a person having personal knowledge of the relevant facts and records. No more robo-signing and no more affidavits riddled with hearsay allegations. Plaintiff debt buyers will be required to submit full and complete documentation in order to make out a prima facie case in support of a default judgment. No more affidavits that rely on boilerplate language and cryptic data taken from spreadsheets and bulk files that merely list the debtor's account as one among dozens or even hundreds of credit card accounts. Instead, plaintiffs will be required to submit affidavits from the original creditor identifying the specific account at issue with a copy of the credit agreement. Each prior owner of the debt stating when they purchased and sold the debt and the amount owed at the time of sale. And the plaintiff stating the amount owed itemized by principal, interest, and other charges, and the complete chain of ownership of the debt with copies of all written assignments of the debt. These are very basic things. By requiring these affidavits, we will ensure that creditors meet the substantive and evidentiary standards for default judgments required under New York law. In addition, to prevent the practice of suing on debt when the statute of limitations has expired, we will expand statewide the requirement that the plaintiff or its counsel submit an affidavit stating that the statute of limitations has not expired. In order to combat sewer service in consumer debt cases, we will adopt on a statewide basis the additional notice rule that we have successfully tested in New York City Civil Court. In addition to filing an affidavit of service swearing that the court papers were served on the debtor, the creditor must submit to the court an envelope bearing the return address of the clerk's office and containing a further notification of the lawsuit addressed to the debtor. The notice is mailed by the clerk's office to the debtor at the same address listed in the affidavit of service. The court will not grant the default judgment in any case where the notice is returned to the court because of an unknown or wrong address. This rule will decidedly help to lower the high default rate in our state. Further, we will be reviewing the procedures and forms already in use in specialized consumer credit court parts and exporting the best practices to the entire state. This will ensure that unrepresented debtors who appear in court have access to comprehensible information and resources so that they can understand the claims against them and formulate appropriate defenses. One of these best practices includes a consumer credit answer form specifically designed for self-represented litigants, which is written in plain English and sets forth a list of standard defenses that creditors can simply check off where applicable. Finally, we will work with local bar associations, law schools, and providers to increase pro bono representation of debtors in consumer credit cases in the hardest hit areas, similar to the great advances we have made in increasing legal representation for homeowners in foreclosure cases. We have many excellent programs to draw upon as resources for increased legal representation and assistance, including the Consumer Debt Volunteer Lawyer for the Day Project, the Attorney Emeritus Program, and the Claro Program, just to name a few. Equal justice demands a level playing field. With all of us in the legal profession, the bar, and the provider community working together to ensure legal representation in this critical area of consumer rights affecting tens of thousands of New Yorkers around the state. With the comprehensive reforms announced today and the ongoing efforts of our partners in the executive and legislative branches, I have every confidence that Law Day 2014 will mark the day that New York State set the national standard by which consumer debtors receive fair treatment in the courts. Thank you. Thank you so much. I am delighted to introduce our next speaker, Mylan Dennerstein. As counsel to the governor, she is a powerful force in state government, a brilliant lawyer, and an independent thinker. Mylan Dennerstein is a true partner in government to the judiciary, a delight to work with, and a fabulous representative of Governor Cuomo. I am so pleased and delighted that she has agreed to be our guest speaker today, or one of our guest speakers. Mylan?
I truly love being introduced. I think it is one of the best things in the world, and I'm always hopeful that my parents could be present because they would be so proud of those kind words. So thank you, Chief Judge Lippman, and thank you to all of you, all you distinguished guests, for being here. I'm going to focus on, with respect to voting, I think how much we take for granted our democracy. The basic civics text model of the relationship between voting and the rule of law, periodic elections occur during which citizens have the opportunity to debate things, and various policy initiatives are rejected or accepted, and life goes on. Only a fraction of those eligible to cast a vote actually do so. This is true of both federal and state elections. In fact, voter turnout in New York State during the 2010 election was the lowest of any state that year. Fewer than 40% of our state citizens voted. To me, lower voter turnout exemplifies how much we as a society take for granted. And we absolutely need to do everything possible to encourage people to vote. But people do get elected. People become governors and attorney generals. And how do we ensure the continued legitimacy of the rule of law under these very real circumstances? Even in the absence of robust citizen participation in the process of governing must continue. The government's duty to develop, to debate, to enact specific laws and policies cannot grind to a halt because of low voter turnout. Every day, critical issues must be addressed to ensure the welfare of our citizens. To me, no area illustrates this principle more than the criminal justice arena. A criminal conviction can lead to the loss of liberty, sometimes completely and permanently, as well as to the loss of property and a variety of other restrictions that affect employment, residency, and other core aspects of everyday life. And we also know that these issues have significant fiscal and moral implications for our society, regardless of whether you vote. Consequently, I think as lawyers, we all agree in this room, we must do everything possible to get it right. The stakes are just too high. Governor Cuomo's administration has strived to confront these issues and the implications they raise by working with the legislature to pass great laws that make our criminal justice system stronger, and by using executive power to do the same where possible. I don't know if many of you know this, but 40% of our prisoners re-offend within 3 years of being incarcerated. That is not a fact that we as a government should ignore. We should do everything within our power to try to address it. As Governor Cuomo has said, prisons cannot and should not be viewed as a tool for economic development. And although our rates of imprisonment continue to fall, and although Governor Cuomo has taken the unprecedented step with the assistance of the legislature of closing 24 adult and juvenile detention facilities, eliminating over 5,000 beds, obviously what we're doing in prison isn't exactly working. And even though these closures yield significant budget savings, we need to do more. So what can we do? As the executive, one of the things we can do is try to ensure that prisoners don't reoffend, because that is good for everybody. It is good fiscally, it is good morally, it is good for the individual. And as part of that, we've participated in many different grant programs that enable us to provide job opportunities when an inmate is released from incarceration. The Work for Success program is one such example. 152 businesses are participating, and over 2,400 formerly incarcerated individuals have been hired during the first 2 quarters of 2013. In addition, partnering with the federal government, we've been able to obtain a grant, Pay for Success, and that has enabled, will enable another 1,000 or so former inmates to receive appropriate training so that they can actually perform a job that's needed. Another thing the executive has done is decided to look at how we are funding programs within prisons that attempt to provide rehabilitation, because the governor very much believes in results. Results First is a comprehensive cost-benefit analysis tool that forecasts the costs and benefits of various criminal justice programs, such as cognitive behavior therapy and job training. And based on that analysis, we've been able to allocate, with, again, the assistance of the legislature, over $15 million to fund various programs that are indeed working. In addition, one of the things the executive can do is settle cases to bring about reform with our partners in the Attorney General's office. And one area we've been able to do that with respect to prisons is groundbreaking changes to solitary confinement practice in New York. And we recently entered into a settle agreement with the New York Civil Liberties Union to reform New York's treatment of inmates subject to disciplinary sanctions, which was solitary confinement, which was really out of line with the rest of the country. Doing these things every day are what we do to try to improve our system to make sure that it works better. Juvenile justice reform is another area where I think we've had undeniable results. Under Governor Cuomo's Close to Home initiative, New York City youth requiring a non-secure placement are now being served in the city of New York instead of being transferred to places far from home and facilities that are often too far for their families or support networks to support them. This change has also contributed to a major reduction in the number of juveniles in juvenile detention facilities, down 44% between December 2010 and June 2013. The number of juveniles placed in detention overall has declined by 23% in the past 2 years. That's an example of what we can do within the system. What else we can do, even if we can't necessarily pass a law, and I know this is something that Judge Lippman and others have worked tirelessly on, is videotaping interrogations. Again, to improve the outcome, the product of the outcome. We want to ensure that people are properly prosecuted and properly convicted. And videotaping interrogations, all the evidence shows, assist in that endeavor. The state awarded nearly $700,000 in grants, enabling 150 different local law enforcement agencies to purchase the equipment for the first time or to upgrade their existing systems that allow them to properly videotape interrogations. With this investment, the state has provided more than $3 million to allow law enforcement agencies to implement the practice, which is widely recognized as enhancing fairness. Every county in New York now has agencies, law enforcement agencies, that videotape interrogations, and that is a first for our state. And with our partners in the legislature, under Governor Cuomo's leadership, I think we've accomplished some really terrific things. I was lucky enough to be personally involved in the passage of the SAFE Act, which is, to me, just common sense gun control measures to keep guns out of the hands of people who shouldn't have them, and to continue to permit people who should have them to do the things they like to do with them, like hunting. I can't stress to you how proud I am to have been involved in that effort and to have worked with partners in the legislature to make that a reality in a time in our country where really, unfortunately, the federal government wasn't able to act. And one area that I view as just common sense is the New York State closed a loophole about the sale of private guns, meaning that you should go through a background check if you're buying a gun from your friend, or if it's from a stranger and you're selling to a stranger, that person should be a background check because nobody wants a gun to end up in the hand of a felon. Those simple kind of common sense measures, I think, make our state safer and are important, and that was passed with really bipartisan support in both houses. So it's a tremendous accomplishment. And another thing that I had the pleasure of working on legislatively was the expansion of the DNA database. And that was a piece of legislation that people have been working on for many years preceding this administration, but fortunately we were able to close the door. New York became the first state in the nation to require DNA samples from anyone convicted of any felony and any penal law misdemeanor being the big expansion. As a result of this expansion, there have been 359 cold hits linking evidence from scenes of unsolved crimes to offenders. And that wouldn't have happened but for this law. Under prior state law, DNA data could only be collected in less than half of the actual crimes people were convicted of, limiting its use in our justice system. And sometimes people view DNA as a tool to prove someone's guilt. It is that. It also proves people's innocence. And it's important for both sides. And again, it leads to a better criminal justice system. And I think that's a great accomplishment, and I'm proud to have worked on that. Partially as a result of these efforts, believe it or not, New York is the safest large state in the country. Only the rural and less populous states of Idaho and North Dakota are ranked as safer. But there's still more work to do, and we all know that in this room, and we'll continue to do it. Governor Cuomo will continue to use all the tools at his disposal, the sound exercise of executive authority, the bully pulpit, the power to strongly advocate legislative reforms, and to promote additional criminal justice reforms, including something we're working on right now, which is raise the age. New York, as many of you know, remains one of only 2 states in the nation whose age of criminal responsibility is treated as adults if you are 16. Following Chief Judge Lippman's lead and building on recent juvenile justice achievements, Governor Cuomo has established a commission to study this issue to try to come up with a solution that works and that is practical. And I look forward to that happening. And the ultimate goal of the commission will be to create a roadmap to promote youth success and ensure public safety so that New York's youth have the same opportunity as other youths to become productive, successful adults. And we will continue to partner with our friends in the judiciary to work on making video interrogation the law of the state, as well as identification. That's something we have been working very closely with the judiciary and many others on, and will continue to do so to try to make that a reality. While a worthy government can and must struggle and strive to work on behalf of its citizens, regardless of whether or not they vote, it's not quite as good as if they did. And to collectively realize the full potential of government to transform our society for the better, we must better engage citizens at the ballot box. Small and large issues impact us every day. And while our democracy is founded on the power to vote, it really cannot flourish until that is fully achieved. And so I look forward to working with all of you to make that a reality.
Thank you, Councilor Dennerstein, for those terrific remarks. And our next speaker, David Shraver, the head of the State Bar Association, represents really in the State Bar one of the largest bar associations in the country. There's more than 75,000 members and going strong. As the 116th president of the New York State Bar Association, Dave Shraver has been committed to issues of reforming legal education, ensuring access to justice for all, supporting the judiciary budget and the need for more family court judges, and representing the men and women of our noble profession around New York State, a role which he has performed with great distinction and skill. I am very proud to have him here with us today for Law Day 2014.
Thank you, Chief Judge Lippman, members of the Court of Appeals, honorable judges, public officials, attorneys, and guests. May it please the Court.
It does.
I am pleased and honored to be here to celebrate Law Day with you, and I thank Chief Judge Lippman for inviting me to speak here today. First, on behalf of all of the attorneys of the New York State Bar Association, I extend congratulations to the 2 Law Day Distinguished Jurist and 4 Merit Performance Award recipients. I join the Court of Appeals in recognizing your tremendous service to the courts and indeed to all of the citizens of our state. I grew up in the city of Albany, on 3rd Street, just a couple of blocks west of what's now Henry Johnson Boulevard. When I am in Albany, I sometimes walk through my old neighborhood. The neighborhood has changed a lot in the past 50 or 60 years. Other things have changed in this city during that time as well. And in terms of our Law Day theme this year, American democracy and the rule of law, why every vote matters, I think things have changed for the better. One of the core values of the legal profession and of the New York State Bar Association is promoting respect for and understanding of the rule of law. Our American understanding of the rule of law is not shared by every country in the world. In some countries, rule of law means protecting the safety and security of the governing regime. In many places, people are struggling to live in a place where their government operates under a rule of law that respects individual rights and freedoms. In places like Syria, Afghanistan, and Ukraine, every day there are heartbreaking reminders of the turbulence and bloodshed that can tear the fabric of life in countries that are not, like ours, governed by the rule of law as we understand it. For many outside this courtroom, the concept of rule of law can sound abstract, like an essay topic in a history class when they took in high school. Many may take the rule of law for granted or never even think about it. But every person in this room understands that it is our country's respect for and adherence to the rule of law, our democratic form of government that preserves the social order and protects our rights and freedoms, that is the essential bedrock for our country's stability. Because of our country's commitment to the rule of law, our citizens can live their lives with the knowledge that their government and its officials are accountable under the law. We strive to have a fair and efficient justice system to which all of our citizens have meaningful access. But the ability of the experiment that is the United States of America to survive as we know it depends on our citizens being knowledgeable and engaged. The theme of this Law Day could not be more important. In many parts of our nation, voting rights, how and when people can register and vote, are under attack. Since the Supreme Court in 2013 struck down a central provision of the 1965 Voting Rights Act, 9 states have passed measures making it harder for citizens to vote, many enacting law requiring government-issued photo identification cards in order to register and vote. Here in New York, in spite of our state's role as a national leader in so many areas, when it comes to voting, our state's voter participation has been in serious decline for over a decade. Mylan mentioned some of these statistics, but I want to note that in the past 3 elections, New York has ranked 47th in average voter turnout, according to a recent report. In the 2012 presidential election, when turnout is usually highest, only 53% of eligible voters cast a ballot. Voting is one of the most fundamental rights as Americans, and yet it is one that fewer and fewer New Yorkers are exercising. Every vote matters and can affect the outcome of an election. Importantly, voting engages the citizen in the democratic process. One of our country's presidents once said, "Nobody will ever deprive the American people of the right to vote, except the American people themselves. And the only way they could do this is by not voting." These are the words of President Franklin Delano Roosevelt speaking in October 1944 in one of his radio addresses from the White House. He said, "The continuing health and vigor of our democratic system depends on the public spirit and devotion of its citizens, which find expression in the ballot box." We at the New York State Bar Association could not agree more. Part of the association's program to promote the rule of law is to educate the public of all ages about our democratic form of government and their opportunity and responsibility to participate in it. In talking about this just last week, a member of our staff recalled how one of his high school teachers had a saying that he tried to impress on his students. "You don't vote, you don't count." "You don't vote, you don't count" is what teacher Dave Murphy at the New Hartford Central High School outside Utica told his students repeatedly, because the concept was so important. At the State Bar, we are working on many fronts to try to get more of our state's residents to count. As part of our 2014 legislative priorities, we are advocating the adoption of a number of proposals to increase voter participation that were recommended by the State Bar's Special Committee on Voter Participation, a committee created by my predecessor, Seymour James. Our committee, whose report was approved by the House of Delegates in 2013, was entirely bipartisan, with 10 Republicans, 10 Democrats, and 1 independent. The Special Committee on Voter Participation was chaired by 2 lawyers of tremendous commitment and experience: John Dunn, former state senator and former Assistant Attorney General for Civil Rights under President George H.W. Bush, and Daniel Kolb, a litigator with over 45 years of experience in federal and state courts. This year, our legislative staff will continue working to bring about the committee's concrete, pragmatic, bipartisan recommendations. To increase voting, we urge the state to modernize its system of voter registration. Between 1984 and 2000, New York's voter participation declined significantly. However, during this same time, other states that had modernized their voting systems experienced growth in participation. One of our proposals is that citizens should have the opportunity to register whenever they engage with a state or federal agency. Another is that they should be able to register online, as they are able to do by mail. We also propose a program for the voluntary pre-registration of 16 and 17-year-olds so that when they turn 18, they will already be registered to vote. Citizens aged 18 to 24 have the lowest rate of registration in New York. Experience in other states and countries indicates that pre-registration programs lead to greater voter participation. Finally, we propose to change the law to allow people to register up to 10 days before an election, a change from the current constitutional requirement of 25 days. Once citizens are registered, exercising the right to vote should not be difficult. To this end, our committee recommends several concrete, pragmatic suggestions to make it easier to vote. The state should improve the design of our ballot to make ballots more user-friendly and easier to understand. And we also recommend that New York adopt early in-person voting, including on the weekend before Election Day. If these recommendations are enacted, analysis and experience in other states and major democracies show that within a few years, New York will substantially increase the percentage of its population that registers and votes. Support for increased voter participation is also one of our federal legislative priorities. In response to the 2013 Shelby County versus Holder Supreme Court decision, the Voting Rights Amendment Act of 2014 was introduced in Congress. In the Shelby County case, the Supreme Court declared unconstitutional Section 4 of the Voting Rights Act that had required states and municipalities with a history of discriminatory voting practices to get pre-clearance by the Justice Department for any voting change. The 2014 bill would cure the constitutional defect by updating the pre-clearance coverage formula, by which states and political subdivisions would be made subject to the pre-clearance requirements of Section 5. Last month, the State Bar's House of Delegates approved the Voting Rights Amendment Act of 2014 as a federal legislative priority because the bill is consistent with the association's overall policy to increase voter participation. And just a few weeks ago, for ABA Day in Washington, I was joined by President-elect Glenn Lau Key and President-elect designee Dave Miranda, members of the Federal Legislative Priorities Committee, and members of our staff in meeting with almost all of our state's congressional delegation. This year, 2014, marks the 40th anniversary of the State Bar's award-winning Committee on Law, Youth, and Citizenship, whose mission is to bring free and low-cost resources and training in civics and law to teachers and classrooms in New York State. Volunteer attorneys, judges, State Bar Association members, and staff visit classrooms, sometimes well over 100 a year, training teachers, putting in hundreds of hours for the committee's mock trial, lawyer in the classroom, and We the People programs. Said one K-12 teacher in Northport, the Law, Youth, and Citizenship program of the New York State Bar Association is our statewide leader in defending and supporting the civic mission of our schools to prepare our children for the awesome responsibility of impactful citizenship in our vibrant and diverse democracy. Law Day 2014. American democracy and the rule of law. Every vote does matter. Thank you.
Thank you, President Shraver. So pleased that you're with us and give those terrific remarks. And now we proceed to what has always been another terrific part of our program, the presentation of awards. It is my pleasure to introduce Chief Administrative Judge A. Gail Prudenti, who keeps our court system up and running and accessible to all, even in the most difficult of times. I'm enormously grateful to her for performing the Herculean job. She looks Herculean, doesn't she? The Herculean job of Chief Administrative Judge with a full heart, great skill and grace, and a total dedication to the well-being of our institution and the public we serve. Thank you, Judge Prudenti, for all you do, and come on up.
Thank you, Chief Judge Littman, for that very overly kind introduction. And I just would like to make a comment. If anyone in this room has an opportunity to have the Chief introduce them, they should do it. I mean, he gives you the deluxe. It's great. It makes you feel good, if nothing else. But good afternoon, everyone, and happy Law Day. As in the past, we do gather here at the Court of Appeals, and it is just always such a pleasure to be in these surroundings to celebrate today. And we always, at this annual celebration, we really celebrate the prized rule of law that has been the basis of our jurisprudence in this country. But my job today is in keeping with another wonderful Law Day custom. So I am delighted to present the 2014 Judicial Excellence Awards to two jurists for their absolutely outstanding contributions. Then the first Deputy Chief Administrative Judge, Lawrence Marks, will distribute the very prestigious Merit Performance Awards to 4 exemplary, absolutely exemplary, non-judicial employees. But I'd also like to take this opportunity to thank each and every judge of the Unified Court System and all of our co-workers and employees that it is an absolute pleasure to work with. In the last few years, I have found that their dedication and tireless hard work has made, I think, all of our jobs bearable, never forgetting our core mission, which is to serve the community in a timely fashion and adjudicate the cases that come before us. I'd like to extend gratitude, of course, to the Chief Judge, Jonathan Littman, who has been a mentor for me for more years than I would like to admit, to all of the associate judges of the Court of Appeals, not just for your support today, but for your support each and every day, whether it's in the budget cycle or whether it's asking your advice. I truly appreciate it. And to my dear friends, the presiding justices, I have a special place for you in my heart, and I know you know that. And to the Governor's Counsel, Mylan Dennerstein. In my estimation, the Governor could not have made a better choice for a counsel and a confidant. And of course, the New York State Bar Association President, David Shraver, who I am sure, for many reasons, is counting down the days till the end of his tenure. But I thank you all, and I thank you for your support of this year's program. The first 2014 Distinguished Jurist Award is going to a Syracuse native, a former Onondaga County legislator and a senior Legal Aid Society attorney. Judge Martha Walsh Hood is a lifelong public servant. She has championed the rights of children. She is respected for her fairness, for her integrity, and for her exceptional work ethic. She was appointed to the Onondaga Family Court in 2000, the year 2000, and then elected to the Family Court. And I think all of us are happy to say that it was the Chief Judge and the Chief Administrative Judge's at that time's pleasure to appoint her an acting Supreme Court Justice. Today, she serves as the supervising judge of the family courts in New York's 5th Judicial District. And I see that the 5th Judicial District Administrative Judge is here, Judge James Tormey. Judge Tormey, thank you for the nomination, and thank you for being here. But the judge has presided over several problem-solving courts. She helped launch and preside over Onondaga County's Integrated Domestic Violence Court. And she helps the district each and every year prepare for an annual adoption day. And if any one of you get the opportunity, it's absolutely heartwarming. The judges and the staff volunteer their time to finalize dozens and dozens of adoptions in just one day. She was kind enough to send me a bell that she uses, and she rings that bell each time an adoption takes place and a child is adopted. And it really is heartwarming. And it was very heartwarming until I took it home, and my husband asked me, could you please take that back to the courthouse? But last but not least, she also brought her talent for organization, and her talent for caring for children and their families, and her talents about just how important adoption is to the national stage this year when she was featured on the Today Show. So we have our very own star of the Today Show. She generously devotes her time, talents, anything we would ask her to do. If it has to do with the best interest of children and families, she's there. She exemplifies the highest standards of judicial excellence, and it is a great privilege to honor her. I would ask Judge Tormey if he would please come up to present to her the 2014 Distinguished Jurist Award. Our next distinguished jurist hails from Suffolk County, and he is the Honorable Fernando Camacho. He joined the Unified Court System in 1997 when he was appointed to the New York City Criminal Court, Kings County. Later, he served on the Queens County Criminal Court bench and took over the role of deputy supervising judges, but at the same time presiding over a domestic violence court, a jury trial part, and a specialized court targeting teens charged with prostitution-related offenses. His work helped spur New York's Human Trafficking Intervention Initiative. He then was elevated to the New York State Court of Claims and designated an acting Supreme Court judge, and then appointed the administrative judge for criminal matters in Queens County, where he served with distinction. He wanted to come back to Suffolk County, wanted to come home, and we both know there is no place like home. And he moved to the Suffolk County Supreme Court in January of 2013. His reputation having preceded him, he was warmly welcomed. The judge really is one of those trailblazers who sets the standard for all judges. You know, in Queens County, he presided over youth diversion court before, it was fashionable. And at this time, he is working with the administrative judge in Suffolk County to develop a similar court. As a judge, he is widely praised by both the bench and the bar, and very much admired for tireless efforts and leading by example. It is my true delight to have my colleague from Suffolk County here today, and I would ask if his administrative judge, Randall Hendricks, is here. I would ask Judge Hendricks if he would please come up to present Judge Camacho with the 2014 Distinguished Jurist Award. Thank you. And a special and a special congratulations to Judge Camacho and Judge Hood. And now it's my pleasure to turn over the program to First Deputy Chief Administrative Judge, without whom I couldn't do my job, Lawrence Marks, to present the 2014 Merits Performance Award. Judge.
Thank you, Judge Prudenti. As we all know, the Unified Court System is a very large court system. We have so many outstanding employees throughout the state, really in every courthouse throughout the state. So it's not an easy thing to identify 4 employees to be honored on Law Day, but I think this year we found 4 people who've particularly distinguished themselves in their jobs and in their lives. So I'd just like to say a few words about each of them. First is Tony Galveo. Erudite yet unassuming, Antonio Galveo began his legal career in 1992 as a central staff attorney in the New York Court of Appeals. Tony went on to serve as a principal law clerk to Court of Appeals Associate Judge Carmen Siparek before joining the Office of Court Administration in 1996 as an assistant deputy counsel to the Chief Administrative Judge. He was later promoted to Chief of Staff, subsequently serving as special counsel to the Chief Administrative Judge and counsel to the Chief Judge. Among his current duties, Tony represents the judiciary in litigation, drafts court rules and legislation, participates in statewide policy, and provides legal support to the administrative board of the courts. Over the course of his distinguished tenure, Tony has played a key role in the development and implementation of policies that have led to important reforms to help bridge the justice gap, enhance professional ethics, advance court technology, promote alternative dispute resolution programs, improve the processing of residential foreclosure and matrimonial cases, and the list goes on and on and on. Tony is admired as much for his resourcefulness, talent as a writer, and exacting standards as he is for his self-effacing collegial manner. His wonderful demeanor, combined with his considerable intellect, vast knowledge of the court system, and outstanding work ethic, have been tremendous assets to the judiciary. Indeed, he is treasured by many throughout the court system for his significant behind-the-scenes contributions over the years. So we are delighted to acknowledge Tony Galveo for his many fine attributes and outstanding body of work with the 2014 Merit Performance Award for superior work performance. And I'd just like to add, I've had the good fortune to work with Tony really very closely for many, many years, and everything I said, believe me, is true. In fact, it's an understatement, and I know the Chief Judge would agree with that.
Absolutely.
A licensed clinical social worker and credentialed alcohol and substance abuse counselor, Joseph Madonia dons many hats as project director of the Brooklyn Treatment Court, which links nonviolent drug offenders to drug treatment and supportive services as an alternative to incarceration. Along with supervising the court's case managers and overseeing its clinical operations, Joe is responsible for implementing court policies and managing the court's federal grants program, helping secure over $3 million in grants in the past 5 years. Collaborating with a range of agencies and organizations, Joe works tirelessly to improve the life chances of treatment court participants. Along with his myriad day-to-day duties, he chairs the court's clinical advisory board and hosts the many local, national, and international dignitaries who visit the court throughout the year. Joe's sphere of influence goes well beyond the Brooklyn Treatment Court. He played a key role in the launch of other problem-solving courts in the borough, including a court that aims to address the unique challenges faced by military veterans returning to civilian life. Working with the New York City Mayor's Office for Veterans Affairs and other entities, Joe helped build a full network of services tailored to military veterans and their families. Always the innovator, Joe was among the first drug court practitioners to recognize the need to identify and address trauma and substance abusing defendants. Over the past decade, he has lent his expertise to numerous advisory panels and conducted drug court training workshops around the state and country. Joe's contributions to the Brooklyn Treatment Court and problem-solving court community have been invaluable, and we're pleased to present him with the 2014 Performance Award for Superior Work Performance. Judge Ferdinand is, where's Judge Ferdinand? If you could come up. Judge Ferdinand sits in the Brooklyn Treatment Court, so if she could come up and help present the award. Gloria Smith Gottinger began her court career 35 years ago in Brooklyn Civil Court, distinguishing herself as a quick study with an eye for detail. For the past 29 years, she has worked in New York County Supreme Court civil term, starting as a courtroom clerk. Always up to the challenge, Gloria was typically assigned to the court parts with the most voluminous, complex caseloads. In 1997, Gloria was tapped to head the state's first office for the self-represented, established to help unrepresented litigants by offering free legal and procedural information. She assembled a terrific team to lead this effort, working day and night in making the office a model for other help centers that have since opened across the state. A few years later, Gloria was again tapped, this time to take on the role of clerk in charge of the court's trial support office, which oversees case management-related functions. She delved into her new assignment, working diligently to promote best case management practices and ensure adherence to timetables for resolving cases. In addition, she helped organize a neutral evaluation program to promote out-of-court settlements in personal injury and other matters, among other innovations. Today, Gloria is recognized not just for her amazing work stamina and can-do attitude, but for her institutional knowledge and mastery of the many automated systems introduced by the court system in recent years. She is also widely regarded for her efforts as a mentor, both to court employees and the countless high school, college, and law students who have interned at the New York County Supreme Court over the years. It's a privilege to honor Gloria Smith Gottinger with a 2014 Merit Performance Award for Superior Work Performance. Actually, it's the court where I sit, and the Supreme Court civil term in Manhattan is a court with an enormous caseload and very challenging cases, and Gloria is without a doubt one of the invaluable people in that court that really makes the court function as it does. What makes Chemung County's Timothy Sweeney so remarkable is his ability to juggle the multiple responsibilities of court officer, family man, and community volunteer and make it look so effortless. Since high school, Tim has been a member of the town of Southport's volunteer fire department, with career, marriage, and fatherhood doing little to slow down his community service activities. In fact, he was promoted to assistant fire chief 15 years ago and moved up to fire chief 7 years ago, giving selflessly of his time in the event of a fire, car accident, or other emergency, late nights, weekends, and holidays included. The town of Southport's volunteer fire department also provides assistance to neighboring volunteer departments, which means Tim's volunteer efforts can take him to Elmira and other municipalities in the area. While most people would be overwhelmed by the emergency-related challenges faced by a fire chief, Tim's dedication doesn't end there. He also devotes considerable time to educating the community about fire prevention. Additionally, he works with local high schools to coordinate Mothers Against Drunk Driving seminars, and he still manages to find the time and energy to participate in pep rallies and other community events. No matter how full his plate is, Tim never hesitates to do more and is always ready to pitch in to benefit others. With his giving nature and sense of civic duty, a great source of pride and inspiration among folks in and around Chemung County. For his exceptional, long-standing volunteer efforts on behalf of the residents of Chemung County and its neighboring communities, we're delighted to present Timothy Sweeney with this year's Merit Performance Award for community service and humanitarian pursuits. Thank you, and I'll now turn it over to Judge Rivera.
Thank you, and good afternoon, and happy Law Day. So I have the great pleasure to briefly describe the Garfinkel Essay Contest Award and to call up the awardees, introduce them to you, and to do the most important thing for them, which is to give them their check. So the David A. Garfinkel Essay Contest is offered by the Historical Society of the New York Court. The Historical Society was founded in 2002 by our own former Chief Judge Judith Kaye as an organization dedicated to promoting New York's legal history and educating our students and the public in general on the role of the courts. This contest is offered each year since 2008 to New York State community college students in our wonderful CUNY and SUNY systems. There are 3 prizes, and the 3 prize winners are selected again by Judge Kaye. Every year, there's a topic that's timely, interesting, intellectually challenging, whether you're a college student, younger, older, it doesn't matter. And this year was no different. This year's topic was Who Watches the Watchers? Free Speech and Free Press in the Electronic Age. This year's winners are Rhonda Parker, Lida Ramos Arce, and Zachary Field. We also have several students who earned honorable mention. Let me just quickly go through their names. Claire Albrecht, Wei Bin Bay, Maisie Lux, Eileen McDonough, Ryan Polito, Amanda Siepersau, Erwin Soraya, Daniela Tashima Valenzuela, Rebecca Woodruff, Mirkala Zuna. Let's give them all a round of applause. The student winners represent the following schools: Adirondack Community College, Genesee Community College, Nassau Community College, Onondaga Community College, and Queensborough Community College. And they were mentored by the following faculty members: Dr. John Arpey, Professor Leslie Francis, Professor Stephen Hamill, Professor Ann Harrison, Professor Rich Jarrett, Professor Christine Mooney, and Professor Charles Scruggs. So, round of applause for my folks. And as you can imagine, it's quite an accomplishment given the demands of school and for many of the students, their personal family and work demands to actually compete. And so I'm really, really pleased to be able to recognize the winners today and those who have been honorably mentioned. As I introduced them, I had gone through their essays, and I do encourage you to read their essays. They're beautifully written. And I just, if you'll indulge me, I've just taken out a few sentences of each just to give you a sense of the level of writing. So I'll start with the SUNY Community College Prize of $1,000 that is being awarded to Rhonda Parker of Genesee Community College. And her essay is entitled Safe and Without Sound. Congratulations to you, Rhonda. To Karen Wicca, Assistant Professor of Criminal Justice, who is here with us today representing the faculty of Genesee Community College. Where are you? Where are you? There you go. Congratulations to you also. So let me just take a moment before I hand the check, which I, again, know is the most important thing we've got to get through. The landscape of the nation is changing. I hope you remember your words. Yes, okay. With the advent of the Internet, information can travel farther and faster than ever before. The fear is that information sharing could get dangerously out of control. There is no absolute way to protect our country from the terrorist threats. This uncertainty is part of the price we must pay for freedom. Our founding fathers may not have been able to fathom the challenges of the modern technological age, but they understood the core principles on which our great nation was built. Quote, "Those who surrender freedom for security will not have, nor do they deserve either one," from Ben Franklin. Well done. Next, I call up the CUNY Community College Prize of $1,000, awarded to Lida Ramos Arce of Queensborough Community College for her essay, Who Watches the Watchers? And congratulations to Lida and her mentor, Dr. Leslie Francis, Assistant Professor of Business, and to Dr. Jonas Falick, Chair of the Business Department of Queensborough Community College, and again, both of whom are here today. Could you raise your hands? One here today. One here today. So just, again, indulge me, because they're such beautifully written words. The U.S. Constitution's First Amendment protection of freedom of the press is just as important as our freedom of religion, speech, and assembly. When government action violates this right and citizens are not aware that it is being infringed upon, this is when society must evaluate and weigh the interest of national security versus their freedom of press. All citizens must be able to exercise their freedoms without any restrictions. These privileges are the base of our democratic society. If they are deprived or restricted, there is nothing left to protect the citizens. In this free society, citizens should not be penalized for uncovering daunting truths. Congratulations. And the grand prize of $1,500, I have the envelope right here, is awarded to Zachary Field of Onondaga Community College for his essay, Balancing National Security and Freedom of the Press. Congratulations to Zachary, and to Dr. David Deacon, who teaches American history at Onondaga Community College, and I understand he's here today. There you go. Congratulations. The government has the legal and moral authority to prosecute unauthorized disclosures that fail to answer to the justifications of transparency and liberty. Unless steps are taken to ensure that intrusions on the press are taken only as an absolute last resort, the government's enforcement of the law may ultimately serve to subvert justice more than aid it. The function of the press is more vital now than it has ever been, as private and public aggregations of power burgeon in size. It is necessary to acknowledge that some disclosures have real potential to cause harm by revealing sources and methods, but other informers have oft proven their necessity to our civil society. As James Madison said, and thank you for letting me close with James Madison, a popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. Congratulations.
Michelle, would you come up? Because as much as we like to, we can't celebrate Law Day all afternoon. So come and sing America the Beautiful, and that will be fun. Michelle?
Oh, beautiful, for spacious skies, for amber waves of grain, for purple mountains, majesty above the fruited plains. America, America, God shed his grace on thee and crown thy good with brotherhood from sea to shining sea. Oh, America, America, God shed his grace on thee and crown thy good with brotherhood from sea to shining sea. God bless you.